Hi and welcome back to another video on A-Level Law. Today we're going to be talking about Magistrates, which composes one of the key units on English legal system, which is on paper 1, Criminal Law and English legal system. We're going to start by looking at what you need to cover for Magistrates, and that is qualifications, selection, work and role and evaluation. You may notice that these are very similar to the topics that you need to know under juries. We're going to start with qualifications. There are three main things you need to know under this: qualifications, the 6 key qualities, and disqualifications. We'll start with qualifications. Lay magistrates must be between the ages of 18 and 70 on appointment. They can work up to 75, but they won't be appointed past the age of 70. In practice, magistrates tend to be very old, or older, I shouldn't say very old. Only 3% of magistrates are under the age of 40, and that's 2016 figures, so it suggests that magistrates do tend to be of the older generations. They must be prepared to sit at least 26 half days each year. In practice, they work many more than that. They must live or work in or near the local justice area, and applications should be able to demonstrate the 6 key qualities which you can see on the right. These are good character, understanding communication, maturity and sound temperament, social awareness, sound judgment, commitment and reliability. Good character is all about not having criminal convictions, having trust and respect for others, being able to maintain confidentiality, those sort of things. Understanding and communication is about having good body language and communication skills. Maturity and sound temperament is being calm and courteous in situations and being mature, listening to advice and those sort of things. Social awareness is being aware of the community you live in and different cultures. Sound judgment is can you think logically and make decisions without prejudice. And commitment and reliability is things like good timekeeping and attendance. There are disqualifications, which means you can't be a magistrate. Anyone with serious criminal convictions is disqualified from being a magistrate. Generally, minor motoring offences might be okay, but it depends on the circumstances. Members of the armed forces are disqualified, as well as police officers, traffic wardens, solicitors, barristers and judges, and any relatives of those people as well that work in the justice system. Anyone that's deaf or blind or has a disability that prevent them from carrying out their duties is also disqualified from being a magistrate. In terms of selection, approximately 700 new magistrates are appointed each year, officially by the Lord Chief Justice, which shortens down to LCJ, who's the top judge, and who makes the officials appointments officially. In practice, local advisory committees actually select the people, and then there are further names to the Lord Chief Justice. Local advisory committees are a mixture of 12 members, a maximum of 12 members, and that includes a mixture of magistrates and non-magistrates. It should be a cross-section of backgrounds, so there should be a split in gender, different ages, and from different jobs. And you can apply to be on the local advisory committee and not be a magistrate if you like. The actual main selection procedure for magistrates goes as follows. You have to apply to become a magistrate, and on that application you have to provide references and also try and lay out why you meet the 6 key characteristics that they need for the job. You will see advertisements for roles in magistrates' courts in papers or on buses, in particular magazines, often aimed encouraging people from ethnic diversities, ethnic groups to apply, as they are short with those numbers. Successful applicants are then called for interview through a shortlisting process. At the first interview, they'll discuss your 6 key qualities and explore attitudes on issues such as youth crime and drink driving and any local crime issues in the area. If you're successful getting through to interview 2, so some people won't be successful, but if you are successful, they'll then look at your potential judicial aptitude, so your ability to make decisions and give reasons for those decisions in a series of case studies and sentencing studies. The local advisory committee will then submit the names to the Lord Chief Justice, who will officially appoint them, and any new magistrates will be sworn in at the Crown Court and undertake extensive training. In terms of their work or role, there are roughly 27,500 magistrates in England and Wales currently. They're historically referred to as JPs, or Justices of the Peace, and they're governed by the Ministry of Justice. Approximately 97% of all criminal cases are dealt with by the magistrates' courts. That's quite often why they're described as the backbone of the criminal justice system. Magistrates weigh up the facts and evidence, they'll deliver a verdict, so guilty or not guilty, and decide on a sentence where the person is found guilty. They can give a maximum sentence of 6 months in prison and £5,000 fine for one offence. There will be a chair of the bench who is supported by 2 magistrates on either side, known as wingers. A single magistrate can sit by himself or herself, but with limited powers, and that tends to be things like minor driving offences, like minor speeding and things like that. Magistrates also can sit in the youth court to hear criminal cases involving defendants aged below the age of 18. These are not open to the public, and magistrates receive specialist training, and interestingly, the panel must include at least 1 man and 1 woman. Magistrates have 4 main functions. They hear applications for bail. They'll deal with early administrative hearings, so that's the pre-trial aspects of mode of trial and deciding whether trial by either way offences should be tried in the Magistrates' Court or the Crown Court. They'll trial less serious cases, that's all summary offences and some trial beneath the way offences, and they'll hear appeals from the Magistrates Court to the Crown Court, whereby 2 magistrates will go and sit with the Crown Court judge to hear those appeals. They're often helped out, or always helped out, by a legal advisor in the court as well. So 3 magistrates will be helped out by 1 legal advisor. This person is often referred to as the clerk or clerk of the court. They have to be qualified as a solicitor or barrister for at least 5 years, and they guide the magistrates on questions of law, practice and procedure. The clerk must not assist in the decision-making process. In terms of evaluation, we're going to go through the advantages and disadvantages of magistrates, starting with the fact that magistrates do represent a good cross-section of society. It's much better than the judiciary. 48% of female magistrates are female magistrates compared to 25% female judges, and that's from some 2015 statistics. I would imagine it's still fairly similar today. There are also campaigns to attract people from ethnic minorities to become magistrates. However, generally, they can be described as middle-aged, middle-class and middle-minded. That's a quote that came from Penelope Gibbs, who did a report onto magistrates. A high proportion are over 40 and from a managerial background, and Morgan and Russell found that they're not a true cross-section of society. In fact, only 7% approximately are from an ethnic minority, and the old report found that they're disproportionately middle class. So there are questions there as to how good a cross-section of society magistrates really are. Second advantage is that they have local knowledge. They know about local crime and local hotspots for crime, but this is diminishing due to closure of local magistrates' courts. And also there is a concern that they may have local knowledge but lack legal knowledge, and that means that they rely too heavily on the legal advisor. And over-reliance on the legal advisor and influence can be seen in the case of R.V. Eccles, Justices Ex Parte Forelli in 1992, whereby the legal advisor got too involved in the decision-making process and the case had to be retried. The third advantage is that magistrates do receive extensive training to help them eliminate bias and to do their job properly. And they work as a panel of 3, which should help to cancel out any bias or prejudice. However, there is clearly a prosecution bias and a tendency to side with the police and prosecution. The acquittal rate is only 20%, so that's where they find people not guilty, which means the conviction rate is 80%. The acquittal rate, as I said, was 20%. That's far below the 50% acquittal rate in the Crown Court. There are also finally fewer appeals. In 2004 it was less than 1% of the total number tried. This suggests that magistrates are making fair and accurate decisions. However, there clearly is inconsistency in sentencing, often described as lottery sentencing. The Liberty study in 1990 found that twice as many defendants were sent to prison in Greater Manchester than in Merseyside for the same offence, and the Home Office study in 1995 also found major differences in sentencing practice. I hope you found that useful. If you did, please subscribe to us on A-Level Law videos, David Lysett, and visit us on Instagram at Law at Portsmouth College. Thank you.